Good morning, everyone. Thanks very much for joining us. We really appreciate people taking the time out of their day. My name is Felix Levay. I'm joined by Conor Wright. We are both barristers here at St Philip's, practicing in, among other areas, in personal injury. I'm quite glad to have Conor with me, a bit of an expert on costs. And so if you've got any hard questions, please save them for him.
Thanks for that, Felix.
We've got, just to say that we're using the chat function and we'll be keeping an eye on that as we go along. So if you've got any questions or anything like that, please just write them in the chat function. We'll try and come to those at the end. The topic today is navigating and, more importantly, disputing fixed costs in personal injury litigation. It's never been, I don't think, really a simple topic, but it's become a lot more complex post-October 2023. And we've now got some additional points, some case law to consider. And so today we're going to be just reviewing the basics and looking at a few important points. So just in terms of our agenda, we want to review the rules, we want to look at how we got to where we are, what's actually changed. We also want to look at track allocation and, importantly, complexity bands, because I think those can be as much of a sticking issue between parties as track allocation. We're going to actually calculate some fixed costs, which is something that seems like it's going to be easy, but I think actually it's really easy to make a mistake doing that, and quite often you'll see a schedule which has made a few errors. And lastly, we're going to be looking at how you get out of the fixed recoverable cost regime, because there are some escape clauses that you can make use of.
Yes, asterisk.
Yeah,
as we'll come to see.
As we'll come to see. So, how did we get to where we are? I think a lot of you will agree with us that there seems to be in the popular imagination, slightly exaggerated view of the amount of money that is to be made in personal injury litigation. But in any event, as part of the Jackson reforms, there was a concern that the system as was, particularly as regards personal injury, was a recipe for runaway costs. And while these reforms were not only aimed at personal injury, I think they certainly have had a big impact in terms of personal injury litigation. A nice quote that we thought it'd be nice to have on the slide is from the then Conservative Minister of Justice in 2019, saying that the fixed recoverable cost regime that came in 2023 would improve access to justice for many. I mean, I think a lot of us do actually have concerns about the ease with which claimants in lower value personal injury claims can secure representation, but certainly that was the official line. There was considerable pushback, and you may remember there was actually concerning clinical negligence and where that would fall in terms of intermediate or multi-track. There was a judicial review brought by Association of Personal Injury Lawyers. That's no longer pursued after some government concessions. But there has been a fairly significant pushback, I think. The name of the game is to improve efficiency in primary and cross proceedings. And I think we'll have to wait to see whether the evidence bears that out as we go along. I mean, it's still relatively early days.
Yeah, made all the more difficult now for many. I'm sure many of you will be aware of the Mazur and Charles Russell Speechley's decision that's been hot off the press over the last couple of weeks. I won't go into in any detail, but of course there is discussion now around the extent to which grade D fee earners can conduct litigation even with supervision, as opposed to assisting in the conduct of litigation, and what exactly that means. There's been an awful lot of press about how that's going to impact especially insurance firms, and so that is something that's certainly worth bearing in mind, albeit I'm not going to cover it in any detail today.
So moving on to the relevant rules that we're going to be looking at, specifically which parts of the CPR are important. We're looking at CPR part 26 and the relevant practice direction, which is about case management and concerning allocation. Part 28, practice direction, looking at the fast track and intermediate track, and of course part 45, fixed costs. There are also, as of 2025, 2 civil procedure amendment rules to take into account. So where were we and where have we got to? I'll just check also, are we keeping an eye on the chat just to see if people are?
Yes, well, shall we cover it at the end?
Yeah, just make sure people are asking questions. So before the 1st of October 2023, system as was, CPR 45, we had section dealing with RTAs, section dealing with pre-action protocols for low value PI claims and RTAs and low value ELPL claims. Section 3A dealing with claims that had fallen out of those protocols. Section 3B dealing with pre-action claims under the pre-action protocol for PI claims below the small claims limit and RTAs. And Section 6 dealing with fast-track trial costs. Now, of course, fast-track trial costs was essentially the cost of representation at a final hearing. So it limited those costs, but it did not impact the costs before that point. We now compare that with how things stand after October 2023. Several sections no longer exist in part in CPR 45. When we look at the fast track complexity bands, we'll see that a few of these have been essentially they almost remain in the sense that they've been some of these types of claims have been assigned to different complexity bands. But the really important point, obviously, is that we now have fixed costs in the fast track, fixed costs in the intermediate track. There's also a disbursement section. But we're now looking at fixed costs throughout both tracks at every stage of the litigation. So in terms of the intermediate track, it is a very big change because obviously multi-track used to be above £25,000. So I think it's interesting both in terms of being this middle ground between £25,000 and £100,000, but middle ground both in terms of value, obviously, but also in terms of complexity, because you get 2 experts per side as opposed to 1 expert per side in up to 2 fields. You also have a length of hearing which can go up to 3 days. So it isn't just it isn't value alone. I mean, they can be slightly more complex cases, given that a lot of them are cases that would have been complex enough for the multi-track as was.
Absolutely.
And again, the important point: only the multi-track now does not have fixed costs. It's a very big change, and I think particularly intermediate track, obviously, that's going to have a very big impact on certain practitioners. So at the time, it was obvious that implementation was going to be a bit of a nightmare. And even now, we still have to pay a lot of attention to the details of a case in order to work out what regime we're under. And I think that's something that is people get wrong sometimes. You assume something that's not true at the beginning, and then only later do you realise you've been assuming that you were on one regime pre-2023 when actually you're post-2023, or vice versa. So the standard position is that if you bring a claim, if a claim was brought after the 1st of October 2023, you are on the new regime. So you bring a simple contract claim, that's where we are. Personal injury is the date of accrual. I think that the point there is that, particularly given that you've got your 3 years limitation, and given that the amount of time that some cases take to work through through to trial, it's very common to still have claims that are still on the old regime. I've got tons. I know that you've had tons.
Yes.
And that is, I think, quite easy in that area, just to get it slightly misunderstand which regime you're under. Really important to know when was the date of the accrual of the cause of action.
Very often that, certainly my experience, picking things up later on in the litigation process, and things have either been allocated a band, so on the new regime where they shouldn't have been, or not allocated a band where they should have been, and there's always that bit of conversation at the start, getting things properly allocated. I think sometimes a bit of guidance from counsel in a hearing is helpful to get things back onto the right track.
Yeah.
Pun intended.
Disease claims, that the date goes from when the letter of claim was sent to the defendant. Housing claims, there was a delay of 2 years. So you're looking at that. You're also looking at particular types of claim. Some claims are inherently complex enough that they need to be assigned to the multi-track. So asbestos lung disease claims, abuse and neglect of children or vulnerable adults. Police claims involving intentional reckless torts. Worth noting there that you are not excluded from that is negligent driving, because otherwise you would have significantly more. Those are going to just be treated as RTAs. Jury trials goes without saying. Clinical negligence. So interestingly, this was the point of contention as regards the Association of Personal Injury Lawyers. There was a real concern that clinical negligence claims are obviously incredibly complex claims sometimes. There's a lot of expert evidence needed. That given if issues settled, at what point issues settled, you might end up assigned to the intermediate track, and therefore not be able to recover the relatively large amount of costs that you had suffered. What happened was, the reason that judicial review was dropped was the government's position became it will be assigned to the intermediate track if and only if in the defence the defendant is clear that they don't dispute liability. And so if breach of duty or causation is disputed, that has to go on the multi-track. So let's look at the complexity bands then in the fast track. And this is, as I said, I think this is something where increasingly you will have some contention over these sorts of allocations. I know I've had them in allocation hearings. I know you've had them in allocation hearings. You know, a lot of back and forth. And again, we've talked about keeping an eye on when your claim was brought or when the date of action accrued. It can be a bit of a warning sign if you're missing an allocation to a complexity band, or you've got one and you're not expecting one. So if you don't expect to be allocated to a band and you have been allocated to a band, do double check, because that does indicate that there's been a misunderstanding about which regime you're under. As I've said, what used to be sections of Part 45 setting out specific regimes have now moved on to the complexity band. So it's relatively prescriptive in the sense that, as you can see, a lot of particular types of claims have been allocated to the relative to the respective complexity bands. There is some wiggle room, but I think it's quite difficult to break out of the typical complexity band that you'd be assigned to.
Yeah, I think perhaps one example that springs to mind where there's certainly room for argument is things like LVI, low velocity impact, where we might be able to fall into that catch-all claims that would normally be allocated to the fast track but are nonetheless complex. There might be argument, especially with claimants, to say, well, a case like that needs to fall within band 4, and that would then give them a little bit of headroom to do the necessary argument on both sides.
Yeah. So we now come on to the intermediate track, and I certainly think this is interesting in that I'm not aware. We had a conversation about this, didn't we, yesterday, about thinking about what kind of case law has come out clarifying disputes about bans in the intermediate track. And I think the answer is there isn't much at the moment.
No, it might be a symptom of the fixed costs that apply to interim applications, which we'll come on to see, and indeed also the extent to which parties want to litigate the complexity band allocation to the point where it becomes newsworthy or indeed binding for the rest of us. So I'm not aware of too much indication as to how these bans in particular apply, especially in a binding fashion, though it's something that's ripe for argument in terms of especially what becomes an issue, but that's perhaps a bit of foreshadowing to the next seminar next week. But yes, so nothing binding as far as I'm aware.
And as we can see, while certain types of claims are indicated as likely to be included in certain bans, there's an underlying logic which goes one issue and dispute, and the trial is expected to be a day or more, ban 1. More than one issue, ban 2, more than one issue in dispute, and it's too complex for ban 2, ban 3, and if it's too complex for the other bans, it goes to ban 4. And I think one of the things that this raises is what is an issue, and a situation in which you've got people arguing about how many issues are actually, how many things are actually an issue. So I personally am quite interested to watch this space and just see what clarification there is on this. So we've done a whistle-stop tour then of what the changes are, what the bans are. But the next stage is actually working out what costs are in a specific situation. I'm quite happy to hand over to Connor for this bit because I actually think it's the more complex part. So we'll hand over. I'll hand over to Connor now, and Connor, you take us through how we actually work out costs.
Thanks very much, Felix. So what I'm going to do here is I'm going to give an indication as to where the rules are and where to look for certain issues. Just in the interest of time, I'm going to focus on doing that, and then any questions that anyone might have, of course, we can address those at the end. Just a little overview here of how it all works. Something that's not on this slide and that might be worth bearing in mind is that litigants in person are dealt with under the fixed cost regime under CPR 45.4. I'm not going to go into any more detail than that, but just bear in mind that it's there. 45.6 defendants' costs have parity with claimants' costs. Obviously, something that doesn't apply to the small claims track, and so both parties. This is all relevant to both parties. Claim and counterclaim carry their own costs entitlement, again, because both are claimants, and I'll come on to the situation with multiple defendants shortly. The fast track is dealt with in Practice Direction 45, Table 12. Do bear in mind that that is the place to look. So the Practice Direction sets out all the tables of fixed costs, and rather than them being strewed about the relevant parts, they are instead set out all in one go in the Practice Direction, and you can work your way through. We'll see some of those in a moment. So that's the fast track. The RTA and ELPL, while the claim is within the protocol, is dealt with now at tables 10 and 11. Intermediate track is table 14. Just a pause for thought on specialist legal advice. The only time that specialist legal advice costs are recoverable are on fast track band 4 and the intermediate track cases, and that's set out at table 13. We've also obviously got the disbursement section similar to what we had before. Do bear that in mind, although, as I'll come to note again later, there is a distinction between recoverable costs and obviously chargeable costs. So it's always worth bearing in mind what the recoverable costs are, but of course that doesn't prevent us from agreeing with the client that the cost paid by the client should be different. Just moving on then to have a quick look at table 12. Broken down into 3 parts. The first part is prior to issue. The second part is before post-issue but before trial, and the third part, section C there at the bottom, is if the claim is disposed of at trial. If you're out with band 1 complexity, the general way that it works is that it will be a fixed amount plus a percentage of the damages, and they're all set out in the relevant table. So you'll work your way down. It works broadly in terms of how much of the litigation has passed, and pick your complexity band. That should then give you the appropriate box for working out what the fixed costs are. Trial advocacy fees, these come under the same table, but I wanted to give it some space on the slide. An interesting development in terms of trial advocacy fees, we see there at subsections 5 and 6. And in those parts, it's set out that costs are still recoverable in the event that a case is removed from the list or settled to a certain degree, depending on how far before the trial it is. And so in those circumstances, obviously a massive change from the previous regime, which didn't provide for that. Something well worth bearing in mind on the new regime, and certainly a benefit, I think, for those trying to recover costs. This set of values is a bit more straightforward. Again, we're working from the complexity bands, but it generally just works on value. Do bear in mind that it's the value of the claim. Table 14 works in a broadly similar way. The underlying regime is more or less the same, but it is obviously increased in its detail, its complexity, to account for some of the differences that we might see as a result of the cases being more complex. We obviously now at stage 7 have the provision for specialist legal representatives advising following the filing of a defence. So that again is a change that also applies to band 4 cases on fast track, but just something that's worth bearing in mind there. Trial fees, much the same, and I apologise that the writing is somewhat smaller than we would want it to be. Unfortunately, the wealth of information that's available makes things rather difficult. I think best advice in terms of calculating these costs is just have a copy of the white book in front of you, or go on the .gov website and get a copy of the practice direction up. It's always safer to just look it up. Some interesting parts of this are stages 12 to 15. These account for things like handing down of judgments and approval of infant settlements, unless it's approved at trial. Very interesting because, of course, those things aren't covered on the fast track and don't necessarily attract their own fixed recoverable costs. So that's a significant difference there in terms of how we progress from fast track to intermediate track. Finally, table 1. This, I think, of all the tables that I've mentioned, is probably the biggest opportunity for a word of warning, which is that if you have a pre-action or interim application, which encompasses the vast majority of applications that come within litigation, the costs are fixed. They're fixed in accordance with this table, and many would argue that the amount that is fixed isn't necessarily commensurate to the amount of work that goes into the application.
I think that's fair to say.
There have been a number of cases recently where parties have engaged in quite complex litigation, and then it's been deemed a pre-action or interim application, and they've been lumped with the fixed costs. Please do have one eye on what these fixed costs are before you embark on litigating your application, because the degree by which parties can be stung is pretty significant, I think it's fair to say. We've obviously got interim injunctions, interim payments for 750 quid there, so do bear that in mind. Some guidance then, and these are just a collection of my thoughts arising out of a series of cases that I've done recently, among other things, things that I just wanted to highlight as we're working through. The first thing I put on there is Bird and Acorn Group, and I know I've done a whistle-stop tour of how the tables work. This is one thing that I see that is overlooked all the time. So Bird and Acorn dealt with, albeit under the old regime, under section 3A, cases that have fallen out of one of the protocols, but then have gone to a disposal hearing. If it goes to a disposal hearing, for the purposes of the tables, it's considered to be a trial. So it comes under the lowest in terms of its position, highest in terms of value, as to how it's allocated under the fixed costs tables. So that's something that I often see is either argued about or is something that's overlooked and has to be reconsidered.
Well, I think we've both had a number of cases, haven't we, where we've had to ring someone up and say, you know, it is essentially a small claim, but actually make sure you've got a statement of costs in there, because you know, you're leaving potentially thousands of pounds on the table.
Well, we'll come back to that in terms of reallocation. The second thing that I want to come back to on this slide is Mill Collections Limited and My Shop 4. There are three things that I want to focus on. It also went into various bits and bobs about litigants in person that I think are helpful if we are dealing with litigants in person, but I'm not going to talk about those today. What I do want to talk about is, first of all, if a claim is struck out, then the defendant is entitled to fixed recoverable costs. Of course, they've got parity with claimant's costs, as we've already discussed. And in that case, it was fixed costs under Table 12 for the fast track, because the claim was struck out. Secondly, and perhaps more interestingly, where there are multiple defendants, each defendant in principle is entitled to separate fixed recoverable costs. So the claimant can end up paying multiples of what's in the table. The court does retain discretion as to whether to order a portion of the defendant's costs. So it could be that there is some sort of other order that works around what might be seen as double charging, but the position in principle is that multiples of those fixed costs can be recovered against the claimant. The third thing is, if you're going to ask the court to deal with unreasonable behaviour, for example, you must have evidence that the conduct has occasioned costs to be incurred, and indeed both a precedent U and an N260, a standard statement of cost, should be produced in circumstances. I'll come back to some of those applications shortly. Precedent U, this is a relatively new invention, essentially a short form statement of cost that deals with fixed costs. It's required 24 hours before a hearing. Just something, again, to keep at the back of our minds, making sure that that's filled out. There is now provision for summary assessment to be carried out on a different day by a different judge, and obviously we wouldn't want costs to be pushed on to a different day, especially if we're falling under the fixed cost regime. Makes sense to put in a precedent U before time. Finally, speaking of it's also worth noting that costs can't be summarily determined for the purposes of fixed costs if the court requires further information. That's what I'm talking about, it being put off to another day. Fixed cost determinations also applies not just as a standalone determination, but also when there is a settlement agreement, when, for example, we have a consent order, a draft consent order, but costs remain in dispute between the parties. So there can be a fixed recoverable cost determination then. And those circumstances can be started under Part 23 in the usual way by N244. It's a modified, detailed assessment proceedings in a way. The default position is that it's determined on the papers. Once the court has filed its own precedent U with a decision on costs, and that's been served, the parties then have 21 days to file a written request for a hearing with the reasons that they want the decision to be reconsidered and a time estimate. Costs for making the application are fixed at £500 plus the court fee. So we can see how that's similar to a provisional assessment, and if a party then requests a hearing, they will be presumed to be ordered to pay the costs of and incident to the hearing, unless they achieve an adjustment in their own favour. There's at least 20% of the sum determined. Of course, disincentivises applicants from disputing relatively small amounts in those circumstances, because they're likely to end up paying costs. Those costs are also fixed as an interim application. Exceeding fixed costs then, we pause to note that the indemnity principle has no application to fixed costs per Sir Rupert Jackson, so you end up with a fixed cost one way or another. We've set out some of the circumstances in which the fixed cost can be either altered or lifted. I said asterisk earlier, and that's because I think these circumstances are relatively rare. What's clear, I think it's fair to say, is that the way in which the fixed costs are intended to apply is that they apply to the vast majority of cases. First of all then, reallocation, and Felix has mentioned this already. We've certainly had plenty of experience where we've managed to reallocate things, either shortly before trial or at trial. It's always one that's worth discussing, especially with counsel once instructed, because as we put at the bottom there, if something is reallocated to a new band or a new track, that applies as if the claim had been assigned to it at the outset. So it completely reevaluates the cost that are recoverable. Things to bear in mind: if a claim is allocated, there will have to be a change in circumstances in order for the track to be reallocated. So we can't just make the application because we don't necessarily agree with it. But if there has been a change in circumstances, for example, we have ourselves a PI claim that was initially indeterminate in some way, and then we've sought further medical evidence, and the value has gone up significantly, as it often does, then we might be able to make that application. So that's our change in circumstances. If the claim is already on the intermediate track, and directions in respect of that claim have already been given, the relevant section reminds us that the court may only reallocate the track where there are exceptional reasons for doing so. So perhaps an application to be considered very carefully before it's made. Otherwise, the court will take into account, per a case called Maguire, the extent to which there is a change. So if, for example, there is a small margin by which the claim now exceeds the relevant financial value for the track, it's probably not going to be reallocated at a late stage. So applications should be made early if that's the case. If there is a large margin, and Maguire tells us that there there probably will be reallocation, but we have to take into account the disruption that might be caused. So my advice on that is to apply early, as early as we can, once things are better determined. If things are reallocated to the multi-track, if our case is reallocated to the multi-track, it disapplies fixed costs completely. There does have to be a reallocation, certainly on the old regime, per CADA and eSure. But once that reallocation has happened to the multi-track, as opposed to, for example, a notice of proposed allocation, the fixed costs are disapplied entirely. It's retroactive, essentially, in the way that it works. Post October 2023, there is some scope, especially for cases that fall out of the protocols. There is some space. It's not necessarily determined at that point what the fixed recoverable costs will be. So there's some scope for argument in that interim period. So practically speaking, parties should pay mind to the track that it should probably be allocated to. As I say, there might be some scope for argument that it wouldn't naturally fall into any of the fixed recoverable cost regimes, and that it should immediately go onto the multi-track. Exceptional circumstances, a bit of a thorny issue. I've put Ferry and Gill there on the bottom of the slide. It's very rare indeed that exceptional circumstances are going to apply, that there is absolutely no departing from the name. The high bar that's established it is perhaps demonstrated by a case in which I was involved, and it's also worth bearing in mind another point from that case, but I'll come back to that. In that case, it was a case that was settled for £135,000, so on the old regime, so significantly above the value that would generally be considered for portable claims. And in that case, the court regarded the exception, the circumstances as not being exceptional at all, and so the then 45.29J provision didn't apply. That's a case called Bosley. It was also said in that case that where a Part 36 offer is accepted, the exceptional circumstances principle doesn't apply at all. Of course, it's on the old regime and it's not binding, but again, an interesting point to note. Part 36, I'm going to scout over this a little bit. I'm not going to spend too much time on it, although it's a very complex subject, because my colleague Dan and I are going to be discussing this in about a week's time. So we'll be doing a whole presentation on how Part 36 works. Please do join us for that. if you want to go into the intricacies of it. For the time being, things to note are the parties can contract out of the fixed recoverable cost regime while making offers, and it can happen accidentally. The Court of Appeal unanimously affirmed that in a case called Doyle and M&D. Now, in those circumstances, that was pre-October 2023, but it's carried over. And indeed, it's confirmed in CPR 45.1. My best advice, in fact, my plea, is please use the form. So many people, so many litigants end up with Part 36 offers that weren't made on the form, and it's so easy for mistakes to be made because the regime is so impenetrable. Please use the form. It's a relatively straightforward tick box exercise, and it largely prevents those mistakes from happening.
Yeah, no, I would say I think when your talk is next week, is it? So,
yeah, next week. Yeah.
I think well worth it, because I would second that. It can be a lot more complex than you think it's going to be.
Absolutely. Final point to make on Part 36 is that rather than indemnity costs, there's a 35% uplift on the difference between the stages. So a slight difference in the way that this applies because it's fixed costs. But again, everything else we'll come back to next week. Not much to say about vulnerable individuals. It's something that of course has been taken into account. Costs need to be at least 20% greater than the ordinary amount of fixed recoverable costs as a result of the vulnerability. Something that's worth considering, but worth considering carefully because of that limit. Unreasonable behaviour, something that is very often considered, litigated, argued, however we want to put that. A swinging 50% penalty on the fixed costs. So well worth arguing if there is something to base it on. What does unreasonable behaviour mean? It is conduct for which there is no reasonable explanation, as we've set out on the slide there. It's a very familiar definition of what unreasonable behaviour is. But a question mark there as to whether or not unreasonable behaviour might create satellite litigation. In my experience so far, it's been dealt with summarily at the end of, I say summarily, it's been dealt with at the end of a hearing as opposed to being satellite litigation of its own. It's been done quite proportionately. But the bar is relatively high, and the Damerman principles still apply. That was a 2017 Court of Appeal case. Just because there is conduct that leads in any event to an unsuccessful result, or more cautious legal representatives would have acted differently, it doesn't make the conduct unreasonable. It has to be, as we say, conduct for which there is no reasonable explanation, so the bar is high. The mill collections I put on the bottom of the slide there, coming back to this case. If, as I've said already, if you're going to apply under CPR 45.13, there has to be evidence of what costs have been occasioned as a result of the unreasonable behaviour. Do put in an N260. London weighting, I'm not going to elaborate too much on this. If you are London based, then examples are the areas served by county courts in central London, Clerkenwell and Shoreditch. It goes out as far as Bromley and Croydon, Dartford and so on. An uplift on fixed costs that apply in those circumstances. So London weighting. Again, just one of my collections of thoughts for you all in closing here. The updates that have already been given in May, obviously as a result of the meeting of the Civil Procedure Rules Committee, there will be a fixed cost stock take and a consultation this autumn and a fuller review next year. They're going to review the operation of the complexity bands on both tracks, the fast and intermediate track. There's going to be a review of Part 36, the exemptions from fixed recoverable costs, particularly in housing disrepair claims, which of course aren't particularly relevant to us today, and the operation of exceptional circumstances and unreasonable behaviour tests. I wonder whether there is some mind to lowering the bar, especially in terms of exceptional circumstances, because it really is hen's teeth. Clinical negligence, fixed recoverable costs remain paused and under review. We've got no firm timescales on that. The government is also discussing the issue of medical agency fees. I put on the slide there the David Richardson case with a one-word précis, retainers. It's really helpful reading in terms of how retainers are dealt with, especially on CFAs. And I just thought that it was a helpful note on how solicitor-client costs will be dealt with in CFA cases, what sort of information has to be given about the retainer to clients, and indeed, finally, the implications of making sure that clients are aware that the costs that are recoverable, the fixed recoverable costs, may be exceeded by their fees under the retainer. And finally then, in closing, I put qualified one-way cost shifting and then mentioned the Tesha case. That case was a real change in terms of what happens in credit hire litigation. Obviously, if there is a mixed credit hire PI situation, very difficult to recover costs from the claimant. In these circumstances now, following Tesha, it is likely that a non-party costs order can be made against the credit hire company. Do feel free to reach out to me in those situations. More than happy to discuss it. But a non-party costs application can, in many circumstances, be made now to recover defendant's costs. And that leaves us then with just the Q&A. I'm going to have a look.
Well, I'll tell you what, I've got them here. So let me read it. So Shahida Bashir asks, can you apply on the day of the trial to reallocate to a different track, and would you be penalised in cost of doing so at such a late stage? Well, I know I have applied on the day, and I know that you have.
Yes, so I think there's a fine distinction to be made. You can apply on the day of trial. Generally, the applications that certainly I've made on the day of trial, especially if oral, as opposed to in an N244, they have been for things like the court has forgotten to allocate a band. And in those circumstances, it's very easy to sort one out. Usually both counsel can knock their heads together and go into the court agreed on what band should be applied. Or indeed there can be a little dispute as a preliminary issue to get that sorted out, or indeed at the end of trial. If you're applying to reallocate proper, my best advice is put in an N244 early, put everyone on notice that you're going to make that application. It is going to have a direct impact on how successful you're going to be with that application.
I think standard rules of any application, do it as early as you can.
Absolutely, absolutely. You know, if you find yourself in circumstances that are less than ideal, you know, don't let it be because you put the application off. Let it be because you've got a good reason for having made that application so late.
So a couple of interesting questions from Sarah Coxon. First, what increased amount of costs are available for vulnerability? If we go back up.
Yes, we can jump back up the slides there.
So I think it's up to 20%, is it?
It's got to be at least 20% greater. It just says the court may consider a claim for an amount of costs. So it's something for the court to consider.
Yeah. So I don't think it's prescribed. If you've got to get up over that threshold, it's not prescribed. Another question from Sarah Coxon. If you suspect the bottom, I think it's quite an interesting question. If you suspect the bottom is going to fall out of your case, are you best issuing proceedings whilst value is still arguably multi-track and getting allocated to this track, or would this not prevent the case ultimately attracting intermediate track costs?
Can I want to be careful about the wording of that question.
Yeah. So basically, I think the question is,
do you issue early so that the value is arguably higher, such that you can get onto the multi-track? Yes, I think is the best answer to that. It depends on the degree to which you think the bottom is going to fall out of your case. Obviously, if you're allocated to the multi-track and then you are unsuccessful, the damage will be much more significant. So it's a balance to take. Yes, I think that's sensible. Issue with the value higher. There has been scope for argument in the past about whether things should be started in the portal or not. Certainly, I think defendants would take the opportunity to try and argue about it. Circumstance dependent, I think, is probably worth saying.
I mean, I think part of that question is, if you start on the multi-track and then you get assigned later on the intermediate track, you get reallocated, what happens to your pre-reallocation costs? So if you're on the multi-track before the intermediate track?
Well, I suppose the same principle would apply as always, which is if you're reallocated, it will apply as if you started from the beginning. So you'd have to get it onto the multi-track and keep it on the multi-track.
Yeah. So I think that's kind of the point, isn't it? If you suspect you're going to end up on the intermediate track, I don't think there is kind of answer to that question. I don't think there's necessarily any advantage of going onto the multi-track. I mean, I suppose potentially in negotiation, obviously, if someone thinks it's going to be a lot more expensive. But no, I don't think there's any point trying to rack up enormous amounts of costs when you're on the multi-track and wait before you get reallocated.
Yes, certainly don't litigate it as if it is on the multi-track.
That's fair to say, huge risk. Last question from Sarah Coxon. If we have encountered an argument from a defendant recently where they have argued fixed costs as the case settled for intermediate track value, but this was after a 30% reduction for contributory, presumably contributory negligence was made. So global value is over the fixed cost threshold.
Good question. I think it's arguable both ways, and it comes down to the definitions, how essentially what I was saying earlier about whether cases would naturally fall into the fixed recoverable costs regime or not, and so essentially they apply from the beginning. I think that's probably well worth looking at. It's not worth us advising now. I don't think that's going to be particularly helpful. Do reach out to us. I will certainly have a look at that for you, and we can discuss it. I think that's probably the best way to go.
Last question from Shoda again. For clinical negligence claim, automatic allocation to multi-track doesn't necessarily follow as it depends on the value of the claim. Is that correct? I mean, I think my understanding of the rule is that if liability or causation is disputed, it does go to the multi-track.
Yeah, I think you're going up to the multi-track with clinical negligence. I think that's fair to say.
So you could be on the intermediate track if it was quantum only. So but that would be the kind of the standard position of trying to work out what someone's.
Yeah, right. You are. I think more likely than not, you're going to go onto the multi-track. Do bear in mind, as we say, Part 26 applies to case management. The track isn't necessarily only determined by value, and complexity and all sorts of other things can apply as well. yes, I think it's more likely than not in multi-track, in clinical negligence cases, that you're going to end up on multi-track, because it's not only limited by value.
Okay, I think, let me just double check. I think we're now on the, we're now at the end of the questions. Yeah, I would repeat, do go to Connor and Dan's presentations on part 36. I mean, I will be, and I will be taking notes, because part 36 and fixed costs, I think are a bit of a headache. And so I strongly recommend you make time for Connor's presentation next week. Thank you very much for coming. I think
just before we close on that clinical negligence point, yes, Felix is entirely right, and what I thought was entirely right. So it goes on to the multi-track unless both it's one that would normally be allocated to the intermediate track, and there has been the admissions that Felix has talked about,
which was what that judicial review was about. Was about, you know, which is why it was dropped, because there was a kind of concession from the government saying no, it has to be conceded at an I think in the defence, I think it has to be conceded then, because of this point about bringing reallocation at a later stage.
Yeah.
Okay, so I think we've got through our questions. As I said, do go to Connor's part 36 talk. I know I will. And if you've got any questions about any of these topics, please do get in touch.
Do get in touch. We're very grateful for you coming. Thank you all, and hopefully see you all next week.